Okay, entering the family court system is without a doubt one of the absolute most anxiety-inducing experiences a parent can go through, right? You've got complex legal jargon, incredibly high emotional stakes, and just this overwhelming fear of the unknown. But what if you actually had a clear step-by-step roadmap to navigate the whole thing? Well, welcome to this explainer. Today, we're taking a structured, evidence-based look at the family court process, and we're specifically zoning in on the organization at the very center of it all. Our goal is to give you the exact knowledge you need to turn all that panic into solid preparation. So, picture this. You've just submitted your child arrangements application. You get a notification, and suddenly this acronym CAFCASS just kind of drops into your life. For a lot of parents, this is the exact moment the real panic sets in. Who are these people? What kind of power do they actually hold over your family? Are you being investigated? Look, these are incredibly common, totally valid questions, but as we'll see today, understanding exactly who they are and how they operate is your single best tool for dialing down that stress. Okay, let's dive into this. Here is our clear 6-step journey to completely demystifying the process. 1. Demystifying CAFCASS. 2. CAFCASS versus social services. 3. The safeguarding process. 4. Section 7 reports. 5. The judge's decision. And finally, 6. How to behave. Starting with Section 1, demystifying CAFCS, covering who they are and what they actually do. Let's start right at the foundation. Before you can even begin to navigate the system, you really have to understand the players involved. CAFCAS stands for the Children and Family Court Advisory and Support Service. They're a non-departmental public body in England. But, what does that actually mean for you on a practical level? Well, it means they act as the court's eyes and ears. They are entirely independent. They don't work for you, they certainly don't work for your ex-partner, and they even operate independently from social services and the court administrators themselves. Their single overriding mandate is to represent your child's interests and advise the judge on what arrangements will best serve your child's welfare. Moving on to Section 2, CAFSS versus social services, and clearing up a really common confusion. Now, a major source of the panic parents feel comes from a very specific misunderstanding. People frequently confuse CAFCS with social services, and we really need to clarify the difference right now because it honestly changes everything about how you approach your case. Now, what's really interesting here is the stark difference regarding the powers they hold. Social services, who work out of your local council, have broad statutory powers to intervene in the community. And yeah, they can actually remove children if necessary to protect them from harm. CAFCS cannot. CAFCS only works with families who are already in the court system. Their involvement is strictly short-term, and they literally do not have the power to remove your children from your home. Their job is simply to advise the court. Realizing that CAFCS isn't there to just take your kids away instantly lowers the stakes. It should honestly help you breathe a little easier. Section 3, the safeguarding process. We'll look at the initial steps and the timeline. So once that initial anxiety is dialed back a bit, what actually happens next? Let's walk through this chronological journey step by step, starting from the exact moment an application is made to the family court. Knowing this timeline completely removes the fear of the unknown. On day 1, when your C-100 application is issued, CAFCASS is automatically notified. Then, usually within 24 to 48 hours, they quietly conduct initial safeguarding checks, which just means they check with police and local authorities to see if there's any history of domestic abuse or child protection concerns. Next, usually within the first week or 2, they'll contact you for a telephone interview. Finally, at least 3 days before your first court hearing, they compile all this information into a short safeguarding letter that's sent directly to the court, outlining any immediate concerns and suggesting next steps. Okay, let's talk about that phone call for a second, because clients so often panic about it. This initial telephone interview is typically just a 20 to 40-minute call, and please hear me on this. It is absolutely not a pass or fail test on your parenting. It's really just an opportunity for the family court advisor to understand the basic context of your family, your current living arrangements, and most importantly, to hear if you have any genuine concerns regarding domestic abuse or your child's safety. You don't need to have perfectly rehearsed, scripted answers. You just need to be clear, honest, and entirely focused on your child. Section 4, Section 7 reports. This is for when a much deeper look is needed. Now, for many straightforward cases, that initial safeguarding letter is totally enough for the judge to make a decision or for the parents to reach an agreement on their own. But if those initial checks reveal complex issues, maybe severe ongoing conflict, or serious welfare concerns, the court will escalate the process by ordering a Section 7 report. Because of the sheer depth of investigation required here, this highly detailed assessment typically takes 3 to 4 months to complete. So we're no longer talking about a quick 30-minute phone call. This is a deep dive into your family's life. Let's move to and see how this actually builds into a complete picture. To write a Section 7 report, the CAFCASS officer will arrange separate, in-depth, and often face-to-face meetings with each parent. They might even do a home visit. Crucially, they will usually speak with the children, typically if they're aged 7 or older, in a very careful, age-appropriate way to understand their wishes and feelings, without putting them in the middle of the conflict. Finally, they don't just take your word for things. They gather objective information from schools, GPs, or therapists to verify the context of your child's day-to-day life. Now, it's really important to know that CAFCASS officers aren't just making arbitrary choices based on, who they happen to like more. Their investigation and their final report are strictly guided by a legal rubric found in the Children Act 1989, known as the Welfare Checklist. They are systematically evaluating things like, what does the child actually want? What are their educational and emotional needs? What happens to them if we change their routine? Is there any risk of harm? And objectively, how capable is each parent of meeting these specific needs? Every single recommendation they make to the court must map directly back to these specific points.
Up next, Section 5, the judge's decision. Let's clarify who really holds the power.
All right, this brings us to the climax of the legal process. The Section 7 report is filed, the recommendations are in, and you are standing in front of the judge. It is vital to understand the dynamic here. So, the crucial point is this. CAFCASS officers are advisors. They provide independent, evidence-based recommendations. But the judge, and literally only the judge, makes the final, legally binding decision. While judges definitely rely heavily on CAFCASS because of their specialized training in child welfare, the court's ultimate responsibility is to make an independent decision. The judge is absolutely not there to simply rubber stamp whatever CAFCASS wrote down.
And this is actually incredibly comforting for parents who might feel misunderstood by their CAFCS officer. If a report falls short, like if there are clear factual errors regarding past incidents, if the officer's analysis just doesn't logically match the evidence, or if you bring compelling new evidence to light, the judge has both the legal authority and the obligation to depart from the CAFCS recommendation. So yes, the report is highly influential, for sure, but it is not final. Finally, Section 6, How to Behave. Let's get into some actionable advice for your assessment. Knowing the law is only half the battle, right? Knowing how to communicate is the other half. Let's shift gears to some direct, actionable coaching on how you should conduct yourself when talking to a family court advisor. Think about the approach you take. If you use your interview to attack your ex-partner and say something like, he is a terrible father who never cares about the kids, well, you sound bitter, uncooperative, and heavily focused on adult grievances. CAFCASS sees that as a massive red flag. But if you reframe that exact same problem by saying, I have concerns about consistency and I really want to create a stable routine for our child, you suddenly sound incredibly reasonable. You're demonstrating excellent parenting capacity by focusing purely on how the situation impacts your child. And this brilliantly illustrates our next point. Stay far away from demanding your rights. Saying I want 50-50 custody because it's my right sounds self-centered and controlling. The courts simply do not view children as property to be divided equally by right. Instead, you've got to take a child-focused, problem-solving approach. Say something like, I want to be open to solutions that ensure our child feels secure and supported in both homes. This is exactly the mindset CAFCASS is actively looking for, a parent who is flexible and prioritizes the child's emotional security above all else. Let's summarize with a few critical, practical tips for your interactions. Before your phone call, prepare a simple one-page timeline so you don't end up rambling. Always separate true child safety concerns from standard relationship complaints. If you receive a report and it's factually wrong, don't write an angry essay attacking the officer. Just provide a calm, dated correction pointing to specific evidence. Show some self-awareness by acknowledging your own communication flaws. Nobody's perfect, and CAFCASS highly respects honesty. And finally, unless there is a clear safety risk, actively demonstrate how you support your child's relationship with the other parent. Preparation and emotional control are absolutely your best tools here.
As we wrap up this explainer, I want to leave you with this really vital quote pulled directly from the source material. The proceedings are not for the benefit of either party. Consider whether the report is in the best interest of the child. Surviving family court requires a massive shift in perspective. It means constantly and sometimes painfully putting your child's needs above your own grievances. So ask yourself this. In your next conversation with CAFCASS, are you fighting to win an argument with your ex, or are you fighting to secure the best possible future for your child? Keep that focus, and you will navigate this process successfully.